In the previous section, we explored the nature of liens, voluntary and involuntary, and how they can impact property ownership, title transfers, and foreclosure proceedings in Arizona. Building on that foundation, this section examines the seller's legal and ethical obligations to disclose any known encumbrances that affect the property. Encumbrances include not only liens, but also easements, deed restrictions, judgments, unpaid assessments, and any other claims that may impact title or use of the property. These obligations are rooted in Arizona law, public policy, and professional standards designed to promote fairness and transparency in real estate transactions. An encumbrance is any claim or right held by another party that may diminish the property's value, restrict its use, or affect the owner's ability to transfer clear title. Common examples include a recorded mortgage, unpaid HOA dues, mechanics liens, property tax liens, or easements for utilities. While some encumbrances, such as easements, do not necessarily harm the property's value or prevent sale, they must still be disclosed so that buyers are aware of all material facts before entering into a binding contract. Under ARS, Paragraph 32, Twid 156, and ARS, Paragraph 33, 422, sellers in Arizona are required to disclose all known material facts about a property that could affect the buyer's decision to purchase. Material facts include encumbrances that could influence ownership rights or create financial obligations for the buyer after closing. A failure to disclose such information can result in civil liability, contract rescission, and disciplinary action under the Commissioner's rules, R4 28-1101A, which require licensees to act with honesty, fairness, and disclosure of all known material facts. Disclosure of encumbrances under Arizona law. When a seller lists a property for sale, they must disclose any existing liens, easements, judgments, or other title defects that could impair the transfer of ownership. This disclosure is typically made through the seller's property disclosure statement, SPDS, which the Arizona Association of Realtors, AR, provides as a standardized form. Although completion of the SPDS is not mandated by statute, it serves as the industry standard for fulfilling disclosure obligations and protecting both the seller and licensee. For example, if a seller in Mesa has an unpaid mechanics lien from a past renovation project or a second mortgage recorded on the property, these must be disclosed. Even if the seller plans to pay off the lien at closing, the buyer has the right to know about it beforehand. Likewise, if an easement allows a neighboring property owner access across the land, this must also be revealed. The law does not require sellers to perform a formal title search before listing, but sellers are responsible for disclosing any encumbrances they know about. If a lien or easement is discovered later through the title report or escrow process, the seller must promptly update their disclosures and cooperate to resolve the issue before closing. Practical example. Imagine a homeowner, Susan, selling her Chandler property. Years earlier, she installed a solar system through a financing program that placed a UCC-1 lien against the property. Although the system is fully paid, the lien remains recorded because she never obtained a release. When she lists the property, she must disclose this lien, as it could prevent clear title transfer. If Susan fails to disclose it and the buyer discovers it during escrow, the buyer could cancel the contract under the Arizona Residential Resale Real Estate Purchase Contract, which allows cancellation if title cannot be conveyed free and clear of encumbrances. Case example, Hill v. Jones, 1986. In Hill v. Jones, the Arizona Court of Appeals established that sellers have a legal duty to disclose material facts about a property that are known to them, but not readily observable to buyers. While the case specifically addressed termite damage, its precedent extends to encumbrances, since they represent material facts that could affect a buyer's decision to purchase or the property's market value. Failure to disclose such information constitutes misrepresentation by omission, even if the seller did not intend to deceive. Licensee's duty to disclose. The Arizona Real Estate Commissioner's Rules, R4 281101, reinforce that licensees must disclose all known material facts about a property to all parties in a transaction. Even if the seller fails to disclose a lien or encumbrance, a licensee who becomes aware of it must disclose it independently. This rule protects consumers and maintains trust in the industry. For instance, if a listing agent learns from the title company that a judgment lien exists on a seller's property, the agent must ensure this information is communicated to the buyer, even if the seller has not yet done so. Concealing or ignoring this fact could result in disciplinary action by the Arizona Department of Real Estate, ADRE, as well as civil liability for failure to disclose. Timing and resolution of encumbrances. Encumbrances are typically discovered early in escrow through a preliminary title report, which reveals all recorded liens, easements, and encroachments. Once identified, sellers must either clear these encumbrances before closing or make satisfactory arrangements, such as paying them from proceeds at close of escrow. The title company cannot issue a clear title policy until all monetary liens are satisfied or subordinated. For example, if a seller owes back property taxes, those taxes are paid from sale proceeds at closing to remove the lien. Similarly, if a mechanic's lien is discovered, escrow will ensure that funds are allocated for payoff before recording the new deed. This process protects buyers and ensures that title insurance can be issued free of exceptions. Discussion. Why is it important for a seller to disclose all known encumbrances before entering into a purchase contract? Answer. Because buyers have the right to know about any liens, easements, or restrictions that could affect their ownership or use of the property, and non-disclosure may constitute misrepresentation or fraud. What is the role of the seller's property disclosure statement, SPDS, in disclosing encumbrances? Answer. It provides a standardized method for sellers to disclose material facts about the property, including known liens, easements, and restrictions, fulfilling their duty under Arizona law. If a licensee learns of an undisclosed lien, what must they do? Answer. The licensee must disclose it to all parties immediately, even if the seller has not done so, in compliance with the Commissioner's rules. Review summary. Sellers in Arizona have a legal obligation to disclose all known material facts about their property, including any encumbrances such as liens, easements, judgments, or restrictions. This obligation is grounded in ARS, paragraph 32, 2156, ARS, paragraph 33, 422, and Commissioner's Rule, R4 28 1101A. The use of the seller's property disclosure statement, SPDS, provides an effective and standardized way to meet this requirement. Failure to disclose encumbrances can lead to civil liability, rescission of the purchase contract, or disciplinary action by the Arizona Department of Real Estate. Case law, particularly Hill v. Jones, 1986, affirms that non-disclosure of material facts, including encumbrances, constitutes misrepresentation by omission. Real estate professionals must therefore ensure full transparency and diligence to protect both parties and uphold the integrity of the transaction.